Hello, I am Dr. Rajshree Chatterjee, Associate Professor, Department of Journalism and Mass Communication, Jagannath University, Jaipur.
Today I'm going to talk about India's Official Secrets Act, its history and use. It is very important to discuss that what exactly Official Secret Act means. This law meant for ensuring secrecy and confidentiality in governance, mostly on national security, espionage issues. The Official Secrets Act 1904 was enacted during the time of Lord Curzon, the then Viceroy of India from 1899 to 1905. One of the main purposes of the Act was to muzzle the voice of nationalist publications. Indian Official Secrets Act 1923 replaced the earlier Act and was extended to all matters of secrecy, confidentiality in governance in the country. Now let's discuss why this issue was in news. The Attorney General requested for criminal action against those responsible for making stolen documents on the Rafale deal public has brought the Official Secrets Act into focus. Now let's discuss the ambit of the Act. The secrecy law broadly deals with two aspects. One is spying or second is espionage, which is dealt with in Section 3 of the Act, and disclosure of the other secrets information of the government, which is dealt with in Section 5. The secret information can be any official code, password, sketch, plan, model, article, note, document, or information. It is very important to understand this, that the secret form of information can be discussed or communicate in any form. It could be an official code, password, sketch, plan, model, article, note, document, or information. Now the point is, why do we need any review for this? Since the classification of secret information is so broad, it is argued that the colonial law is in the direct conflict with the Right to Information Act. Under Section 5, both the person communicating the information and the persons receiving the information can be punished by the prosecuting agency. The SARC report states that as the USA background in the colonial climate of mistrust of people and the privacy of public officials in dealing with the citizens is created a culture of secrecy. Another contentious issue with the law is that its Section 5, which deals with potential breaches of national security, is often misinterpreted. This section makes it a punishable offense to share information that may help an enemy state. The section comes in handy to book journalists when they publicize information that may cause embarrassment to the government or the armed forces. Let's go ahead. Now, what exactly constitutes the spying? If any person, for any purpose prejudicial to the safety or the interest of the state, approaches, inspects, passes over, or is in the vicinity of or enters any prohibited place, or makes any sketch, plan, model, or note which is calculated to be or might be or intended to be directly or indirectly useful to an enemy, obtains, collects, records, or publishes or communicates to any person any secret, official code, or password, or any sketch, plan, model, article, or note, or any other document or information which is calculated to be or might be or is intended to be directly or indirectly useful to an enemy, or which relates to a matter the disclosure of which is likely to affect the sovereignty and integrity of India, the security of the state, or friendly relations of the foreign states. He or she shall be punishable with imprisonment for a term which may extend where the offence is committed in relation to any work of defense, arsenal, naval, military, or air force establishments, or station, minefield, factory, dockyard, camp, ship, or aircraft, or otherwise in relation to the naval, military, or air force affairs of government, or in relation to any secret officials codes to 14 years, and in other such cases to 3 years. Now, communication with foreign agents to be evidence of commission of certain offences. A person may be presumed to have been in communication with a foreign agent if he has either within or without India visit the address of a foreign agent or consorted or associated with a foreign agent, either within or without India, the name or address of any other person regarding a foreign agent have been found in his possession or have been obtained by him for any other person. There are certain points which are also need to be noted. Willfully communicates the code or passcode, sketch, plan, model, article, note, document, or information to any person other than a person to whom he is authorized to communicate it, or a court of justice, or a person to whom it is in the interest of the state his duty to communicate it, uses the information in his possession for the benefit of any foreign power or in any other manner prejudicial to the safety of the state, retains the sketch, plan, model, article, note, or document in his possession or control when he has no right to retain it, or when it is contrary to the duty to retain it, or willfully fails to comply with all directions issued by a lawful authority with regard to the return or disposal thereof, fails to take reasonable care, also conducts himself as to endanger the safety of the sketch, plan, model, article, notes, documents, secret official codes, or password or information, he shall be guilty of an offence under this section. If any person voluntarily receives any secret official code or password or any sketch, plan, model, article, note, document, or information knowing or having reasonable ground to believe at the time when he receives it, then the code, passcode, sketch, plan, model, article, note, document, or information is communicated in contravention of this act, he shall be guilty of an offence under this section. If any person having in the possession or control of any sketch, plan, model, note, article, document, or information which relates to munitions of war, communicates it directly or indirectly to any foreign power or in any other matter prejudicial to the safety or interest of the states, he shall be guilty of an offence under this section. A person guilty of an offence under this section shall be punishable with imprisonment for a term which may extend to 3 years or fine or both. Now let's discuss how misuse of uniforms, falsification of road reports, forgery, personation, and false documents can lead to the violation of this act. If any person, for the purpose of gaining admission or of assisting any other person to gain admission to a prohibited place, or for any other purpose prejudicial to the safety of the state. Uses of wears without lawful authority. Any naval, military, air force, police, or other official uniform, or any uniform so nearly resembling the same as to be calculated to deceive or falsely represent himself to be a person who is or have been entitled to use or wear any such uniform. Orally or in writing, in any declaration or application, or in any document signed by him or on his behalf, knowingly makes or conceives at the making of false statement or any omission. Forges, alters, or tampers with any passport or any naval, military, air force, police, or official pass, permit, certificate, license, or other document to similar character. Hereinafter in this section referred to as an official document, or knowingly uses or has in his possession any such forged, altered, or irregular official document. And lastly, personates of false represent himself to be a person holding or in the employment of a person holding office under government, or to be or not to be a person to whom as an official document or secret official code or password have been duly issued or communicated, or with intent to obtain any official document, secret official code or password, whether him or any other person knowingly makes any false statement or uses or has in his possession and under his control without the authority of the department of the government or the authority concerned. Any die, seal or stamp or of belonging to or used, made or provided by any department of the government or by any diplomatic, naval, military or air force authority appointed by or acting under the authority of government, or any die or seal or stamp so nearly resembling any such die, seal or stamp as to be calculated to deceive or counterfeits any such die, seal or stamp, or knowingly uses or has in his possession or under his control as such counterfeited die, seal or stamp. Next, he shall be guilty of an offence under this section if any person, for any purpose prejudicial to the safety of the state, retains any official document, whether or not completed or issued for use, when he has no right to retain it, or when it is contrary to his duty to retain it, or willfully fails to comply with any direction issued by any department of the government or any person authorized by such department with regard to the return or disposal thereof, and whether allows any other person to have possession of any official document issued for his use alone, or communicates any official secrets code, password so issued or without lawful authority or excuse, has in his possession any official document or secret official code or password issued for the use of some person other than himself, or on obtaining possession of any official document by finding or otherwise, willfully fails to restore it to the person or authority by whom or for whose word it was issued, or to a public officer. A person guilty of an offence under this section shall be punishable with imprisonment for a term which may extend to 3 years, or fine, or with both. Lastly, let's discuss Iftikhar Gilani case. On September 7, 2002, New Delhi, Iftikhar Gilani, the son-in-law of firebrand Jamaat-e-Islami leader Sayyid Ali Shah Gilani, was charged sheeted by Delhi police for allegedly supplying sensitive documents to Pakistan on the deployment of Indian troops and paramilitary forces in Jammu and Kashmir under Section 3 and 9 of the Official Secrets Act, and Section 120B, Criminal Conspiracy, and Section 292, Obscenity of IPC. The court observed that the Section 3.2 of Official Secrets Act is not necessary to show that the accused was guilty of any particular act tend to showing a purpose prejudicial to the safety or interest of the state. Prima facie, the circumstances are conducted are enough to draw a presumption against the persons so accused. On January 13, 2003, 7 months after he arrested journalist Iftikhar Gilani was released by a special court. The release came after the government, in a volte-face, decided to withdraw the case against him for allegedly possessing sensitive documents relating to troop deployment in Jammu and Kashmir. So here, this is the end of this topic, and in this topic we have discussed that how Official Secrets Act have been started by the British government and later on continued by Indian government as well, and why it is related for the media student to study that how the importance of official documents and the secrecy of official documents need to be maintained. Although in later classes we may discuss its relations with RTI and how it can work on it. With the case Iftikhar Gilani case, I just tried to make you understand the issue and the sensitivity of this act. Thank you.